মিলে হতো না, বলে দিয়ে যাচ্ছিস বলে দিই। Well,
May your lordship time give
I'm
to my
just
lord?
no, I am just only seeking one indulgence from his lordship, my lord, that in that matter, that SOP matter which lordship has heard, my lord, my matter, the only difference of my matter is, my lord, my client is a physically handicapped candidate. In the SOPs, my lord, there is no whisper with regard to that. So I filed a writ petition today, my lord. I supply the number, so let it be listed on Wednesday when this lordship fix this matter.
No. It will be regularly taken up. You file it. If you are
Lordship.
not in the SOP, then why do you worry for that?
No, my lord, they are insisting me to fill up the form so that they can transfer.
You file it and
Lordship, I shall.
My lord,
May I be allowed to leave to my lord, move unlisted, my lord.
Be allowed
No,
to
no.
mention
Already
technical difficulty.
Takun na list.
My lord, the unlisted matter, your lordship, SOP is lordship, my lord. That
SOP, I will first decide on that. There it will
no,
be
my lord,
effective.
additional
Under the-
documents.
No.
I have annexed the, my lord, additional documents, my lord, to show.
SOP, I am not hearing it now. The bunch of matters which has been heard, that will be concluded. I pass order, thereafter will list.
My lord, for correction, one matter may I mention?
Sir, mention Friday.
One
Today, no. Today is not the date for mentioning. Yes. One day, yes. नहीं
My lord, this matter, my lord, need exam, my lord. And my lord, I went to the office of the Learned Additional Solicitor General office, but till date, my lord, has not been uploaded this order. My lord, what has happened, my lord?
क्यों नहीं है देखो
The order was passed on 3rd August. My lord, Monday, my lord. Kindly, my lord, next Monday. But I can start today or tomorrow.
matter is appearing under the heading to be mentioned. অ্যাপিল করছে কি করেছে সুজিত বাবুকে বলো এ করতে advocate for the petitioner seeks to serve in the office of the Learned Additional Solicitor General in terms of the order dated 3rd August 2026. Please this matter next Monday.
My lord.
It will be uploaded in the course of the day. You find out and then serve.
My lord.
It will appear under to be mentioned on Monday next.
My lord.
যাবেন না এগুলো মানডেতে যেন ডেট আছে হয়তো এসেছে ওটা আপলোড সময় এত ম্যাটার থাকছে স্যার Done appears on behalf of the petitioner. রিপোর্ট কোথায় যায়নি আবার 23/7/26 27/7/26 এই অনেক কোথায় গেল দেখি না না নেই ঠিক আছে This matter is appearing. You are appearing. You are for the petition.
I am for item number 4, my lord.
that is appearing under the heading to be mentioned. None appears on behalf of the applicant's petitioner. On the last occasion, that is 27 July 2026, as well, the applicant's petitioner failed to appear. আগের দিন তো আসেনি এদিকে সার্ভিসে কেউ আসেনি None appears on behalf of the petitioner. The alleged contemner is not represented. কি বলবো আর বলুন তো? এত বললে কি করে হবে? ডিস্ট্রিক্ট পাল্টে গেল কি করে? এটা সব পূর্ব মেদিনীপুরের। এই তো প্রধান গৌর গ্রাম পঞ্চায়েত। হ্যাঁ, এ তো পূর্ব মেদিনীপুরে যাবে। দেখে বলো তো, এ তো মহা মুশকিল হয়েছে, এত ক্যাজুয়াল হলে তো আমার বড় মুশকিল। দেখি প্রথম নাম হলো গৌর গ্রাম পঞ্চায়েত। কে টাইপ করেছে? না, এটা ঠিক আছে। এখানে কি চলে এলো? SRM গ্রাম পঞ্চায়েতে পাল্টে গেল। দেখি রিপোর্টটা দেখি। বলুন কি বলো? None appears on behalf of the. It appears from the order dated 19 May 2026 that it was submitted on behalf of the alleged contemner that she could not appear since she was having 1-year-old suckling baby. In view of the above, and it was also submitted on behalf of the LS contemner that the order of this court has been duly complied with. None appears on behalf of the petitioner applicant. On 27 July 2026, failed to appear. In view of the above, the contempt application being WPCRC 91 of 2026 stands dismissed for default. Connected application solo. Rule is discharged. No, is it rule? Dismissed for default. কিন্তু রুলটাকে রেখে দিয়ে হবে dismiss for default করবে and connected application disposed of yeah, rule is discharged. Personal appearance of the Alice contemner also dispensed with.
Item 4, I am for the board loss.
But I am for the petitioner.
On 5th, 18th May loss, that is the board to file evidence loss. I am looking for what extension. The petitioner qualified the year 23, the PET examination.
Sir, Kaushik Chaudhary, London advocate appearing for
I will give a short date, man.
BPE, West Bengal Board of Primary Education, seeks extension of time to file affidavit in opposition in terms of order dated 18th May 2020. Let such affidavit in opposition be filed within a period of 2 weeks. A reply, if any, be filed within this matter after 3 weeks. Put of 2 weeks, 1 week. This matter after 3 weeks under the heading hearing.
Gratefully.
Hearing eligibility.
Under the heading hearing.
Yes.
Item 5.
5, my lord, I am for the petitioner. We are appealing for the DPSP. My lord, kindly comes to page number 20, my lord. Page number 20 of the petition.
20.
20.
What is the mistake?
My lord, the date of representation, my lord.
Will be 23rd January is correct.
Yes, my lord.
23rd January.
23rd January.
Okay.
And my lord,
Will
there is
appear.
one another mistake, my lord.
Huh.
My lord, the cause title, my lord, MD dot. The dot will not be there, my lord.
এর জন্য কি হয়ে যাবে?
MD dot. The dot will not.
এমডিটা তো দেয়া নেই
হ্যাঁ
এমডিও তো দেয়া নেই ওইটাই দেয়া আছে
এই-
ডটটা
হবে না।
দুইজন ফেলাবে dot remove করুন. This matter is appearing under the heading to be mentioned. Inadvertent applicable error is scraped into order dated 30th July 2026 in the cause title mentioning the name of the petitioner as
Just MD, my lord.
Mohammed MD dot Suruj Jaman instead of MD আর dot দেবেন না.
My lord, the cause, my lord, my lord,
Jaman. What happened?
it will be just MD, not MD dot. The
That is also I have been recording.
আচ্ছা।
Oh, extra dot comma এগুলো দিতে হবে. Further, in paragraph number 8, in the 4th line, the date of representation has been wrongly mentioned as 18th June 2025 instead of 23rd January 2026. The date of representation in line number 4 of paragraph number 8 should be read as 23rd January 2026 instead of 18th June 2025. The aforesaid order is modified to the above extent. The other portions of the order shall remain unaltered. This order shall form part of order dated such and such.
Item 6, my lord, the case number is wrongly mentioned, my lord. It's 2025 written, my lord.
That is appearing under the heading to be mentioned.
2026.
In as WCAP header has created into order dated 30th July 2026, mentioning the writ petition number as WPA 4873 of 2025 instead of WPA. What it will be?
My lord,
It will be 2026
26, my lord.
in the cause title, in the cause title as well as in paragraph number 13, mentioning the writ petition number as WPA 4873 of 2025 instead of WPA 4873 of 2026. The writ petition number in the cause title and paragraph number 13 of the aforesaid order be read as WPA 4873 of 2026 instead of WPA 4873 of 2025. This order is modified to the above extent.
Much obliged.
Very good. Last location. Nobody appeared before lordship.
I appear on behalf of the contemnor, my lord. My lord, the district magistrate has given its report, my lord.
Yes, you can hand
As
over.
well as on basis of the district magistrate's report, the PWD has also proceeded with. I think the petitioner had gone for a joint survey. They're saying, my lord, the 28th, 29th July 2026, certain joint inspection had been taken. My lord. My lord, if I may just start with the DM's report.
You were lordship. Again report. The report of the report of the definitely report.
Just a quick.
Report.
My lord, as per the last notice that was given to the DM for giving valuation, they had written to the said PWD officer and said he, as per the new system that has been placed, which is called the VNR module, that the valuation may be done within, and the PWD engineer, who is contemnor number 1, has said it will be done within a week, and the total valuation will be sent to the DM within 2 days. Within a week, and the DM has said within 2 days they will send over the total valuation. Thereafter, the matter will be placed before the finance committee. Now, for the finance committee has also to give approval of the cabinet committee. So in total, they are asking for a two months time to complete all that, so that everything will transfer to them. And DM has said as soon as all these approval comes to them, within a day's time they will give over the money directly to the petitioners. And my lord, and also my lord, this is
You
the
will advocate
status
for the
report with
arrest
regards to-
contemnor.
Order was
Submit
for the
that.
9 December.
This is the status report of the contemnor number 1, my lord.
Okay. What will you do, Mr.
Learned advocate, Mr. So-and-so, learned
Well, again,
advocate
2 months.
representing the alleged contemnor number 1, as well as district magistrate also. You are representing both the contemnors,
Which is Joseph.
huh?
Yes, my lord.
Both the contemnors.
Yes, my lord. The first is the
Alleged
contemnor.
contemnors submits that a joint inspection has been conducted on 29 July 2026 in respect of the subject land for processing the valuation as per the VNR module. What is VNR? This is what is full form of VNR? VNR module.
VNR module is, my lord, a comprehensive module that they have introduced,
Okay.
where each
Our
of the
review is
department
taking
can
some
upload it,
time.
and then the valuation comes from
He-
any of the
he
ADSR, which
further
is
submits
located
that
in the jurisdiction.
the valuation will be completed within a week, and the same will be forwarded to district magistrate for assessment of the total purchase value. He files a copy of the status report submitted by the executive engineer South 24 Parganas Highway Division, PWD Road Directorate, dated 6th August 2026, as well as status report furnished by the district magistrate and collector, South 24 Parganas, dated 6th August 2026, which is taken on record. Give a copy to him.
Copy I have
Just
Copy served. He seeks uh, 4 weeks accommodation to complete the entire process. Let 4 weeks, no?
8 weeks, my lord.
No, whatever passed
Because,
on 9 December
There's another
2024.
process with the
Six-
finance
6
department
weeks,
has
you give a compliance report after 6 weeks. Complete the process. 6 weeks. Please this matter after 6 weeks. Alleged containers are directed to file affidavit of 6 weeks about date borrow. Compliance report on the returnable date. 21st September. Complete the process and come back.
On 20th, they will file a compliance report also.
You have got the copy of that?
Just now I
The
have got.
process has been initiated. Let's see what happens. Complete that process within that period.
I'm on behalf of the petitioner.
On behalf of the alleged contempt, my lordship, there is the compliance report.
My submission is that there is no order decision taken by the contender. If your lordship go through the minutes of the meeting, there is no decision taken by the Pradhan. So, my lord, I want to file exception if your lordship allow.
But let me see what is the exception. If you are agreed, you file.
Because some statement
Order
made
petition.
wrongly made in the minutes of the meeting, despite of submit my written submission, my lord. There is no conclusion, my lord. Whether allow or disallow.
Lordship, on the point number 10,
Point number?
10 on the compliance report, is a settled fact that the construction was made out of the aid provided by the Bangla Awas Yojana. Therefore, the Panchayat Pradhan has nothing to do with it. RW. Beginning is a point. Beginning.
Yes, where is your finding? Finding to the representation made, whether it is correct or not, whether the construction made by the respondent is correct or not. You have not stated so.
Order time.
Where is your decision?
Huh?
Where is the decision?
Decision is not here, my lord, but
Page 8.
my lordship, kindly
Where is the decision?
lordship, then allow me to file another compliance report with a reasoned order.
Your lordship's order, page 58. Clear direction has been passed by your lordship.
Allow, reject, whatever you take a decision.
Page 58 of the contempt application, the order of your
You have
lordship.
stated the facts only, that these things have happened.
There will be a last paragraph to this that was not added by the Pradhan.
Say so. The affidavit of complaint filed on behalf of the alleged contemnor is taken on record. Ms. So and so, learned advocate appearing for the alleged contemnor seeks to file further affidavit of compliance on the learned advocate for the applicant petitioner submits that nothing has been decided in the resolution of the panchayat. After learned advocate for the alleged contemnor seeks to file a further affidavit of compliance on the returnable date, release this matter after 2 weeks. Do সপ্তাহ পর
Okay.
not granting, let them file the further.
Mine.
If you require, then you file your exception.
Fine.
The order is passed and then
Grateful, lordship.
Well, I am for the applicant petitioner. My lord, your lordship, kindly take your lordship's order dated 31st of July. My lord, his lordship.
State authority has prepared an appeal by challenging the order under contempt.
My lord's order at page 31 of the contempt petition.
what is the number? What is the number of the appeal?
Payment number.
Or the
Payment.
My lord, your lordship, kindly take your lordship's order 31st of 20th of March at page 31. Date of order, I don't know whether appeal when filed. But I have the restriction regarding such submission. This type of view has been categorically deprecated by the Honorable Supreme Court in a recent judgment I am placing. Kindly take, your lordship, 2 judgments I shall place. Letter, page 31, your lordship's order, judgment. 20th of March 2025, more than 1 year. There was a mandatory direction at page, internal page 4, for giving compassionate appointment since I am waiting 79. The authority, my lord, after acceptance of all formalities, directed the appropriate authority to issue appointment letter. Even then that was pending. These are documents issued by an authority. Having considered, page 34, internal page 4, having considered the submission advanced by petitioner as well as the state. Kindly
Yes.
take
Internal page.
internal page 4. Having after consideration of all submissions, the Deputy Secretary, Government of West Bengal Panchayat and Rural Development is directed to approve the appointment of the petitioner as per his qualification within a period of 4 weeks from the date of communication of the order. And the respondent number 6, the Block Development Officer issue a consequential appointment letter in favor of the petitioner within a period of 2 weeks from the date of receipt. An approval, mandatory. But kindly take Lordship's communication. I have communicated at page 38 when they have received. Page 38. April 2025. Page 38. First column. Delivered. Item delivered to the addressee. Now they have not complied with within 2 weeks from that. Again, I, my lord, made communication in the month of page, kindly take page 44 letter and receive at page 47 in the month of September. Page 47. Again, item booked, item delivered, bottom 8/10/2025. My lord, got it? Till date, no compliance. Now, my lord, kindly take your lordship's order 31st of July. May I read for your lordship? This is one page. Mr. Falguni Bandhopadhyay, learned advocate, alleged contemner, submits that new incumbent has yet to take charge in the office of the Deputy Secretary. He informs the court the process have been initiated to comply. The order dated 20th of March 2020. He seeks file an affidavit of compliance and matter has been fixed. Therefore, it is his duty to file a compliance report today. Otherwise, this is another flouting. Now, my lord, kindly take the Supreme Court decision 2026. What type of practice has been deprecated by the state? Similarly, kindly take last page, paragraph 27. Supreme Court is annoyed. Page 20, paragraph 27. May I read for? Delayed filing on appeal should be an exception. But in the recent times happening, because the contempt jurisdiction now is diluted under 215. With great respect, I am saying so. The authorities are not complying with. Even after the exception has practically evolved to become a rule. Order passed by the court are not complied with for a long time. And when the contempt petitions are filed, belated appeal with a tremendous delay are preferred. The alleged continuing contumacious conduct by a defaulting party is sought to be justified by mere production of diary, filing, stamp reporting numbers showing an appeal has been preferred. So, to obtain multiple adjournment in a contempt matter, now, we in no uncertain term deprecate this practice. It is felt that such modus operandi disobedient the litigants act brazenly, which has been further affect the bringing down the authority of the majesty of the court and the rule of law, interfering with administration of justice. Same may within the situation border that is criminal contempt also. Now, the High Court should deal with the unscrupulous litigant. Why not kindly see the words has been used? How court has annoyed. More so, when happen to be the state within the meaning of the Article 12 of the Constitution or like bodies with an iron hand, unless the High Court, so long this court deal with this aspect firmly, we run to the clear risk of erosion and unflinching faith in the ordinary litigant. This court, this country reports to the judiciary at levels. It is solemn duty of all of us manning the court across the hierarchy and ensure that public faith never waves. Now they are filing,
Let
mere filing. Now, my lord, kindly take another.
submission before the appeal court, my lord.
It cannot be. Now, kindly seize the judgment of coordinate bench. Mere filing of appeal cannot operate as a stay. Contempt rule was issued. Paragraph.
Last week they have filed, the state authority has filed.
Yes, this is non-est in the eye of law because section 5 has not been allowed. It is submitted by learned advocate.
Regarding section 5.
Let him file tomorrow. Kindly direct the authority to present before your lordship and explain why they delay. And they, even then, to 31st of July, order has not been complied with. Tomorrow, 10:30, let them come to and explain why. It is submitted by learned advocate representing all the contempt non-respondent, such and such, since an appeal is pending and paper book has been made ready. In all contempt non are not in a position to comply with the direction as contained in the order such and such. Now, it is quite well settled that the till an order is passed by a competent court is set aside, stayed or varied or modified. The order remain valid and subsisting and is required to be complied with, both in law and its spirit. If the stand is taken by any person that he and she unable to comply with the valid subsisting order simply because an appeal is pending before the higher forum, it will render
Yes,
the,
Mr. Biswas, wait.
my lord. I am leaving it to lordship. Let them come with the complaints by tomorrow.
Yes, sufficient.
More than 1 year. Mere
Let the
filing an appeal.
Heard, my lord, before the appeal.
Yes.
File the
No.
appeal.
My lord, last week filed the appeal, my lord.
After 31st July.
My lord.
Then
So why didn't you submit on 31st July that you are preferring an appeal?
obliged.
My lord, we at that time, my lord, we have no such information.
Then
My
why
lord.
did you submit before the
Subsequently,
court
my lord,
that the process has been initiated for compliance
the
of the order?
concerned authority, as per instruction, my lord, I have submitted, my lord. The process has been initiated to bring the record from the district, my lord, and subsequently the concerned authority decided to file the appeal, my lord, and filed. Ultimately filed on the last week, my lord. And I am praying for only 3 or 4 weeks time for being stay order, my lord, from the appeal court, my lord.
This is not the first time. On 10th July also similar submission was
My lord, on
advanced.
the first occasion, I have submitted that the incumbent, the contender has retired, my lord. That the Bhudev Chandra Mojumdar, the deputy secretary, was retired, my lord. No incumbent has joined, my lord. And they also intimated that they have started initiated that bring the record from the district and compliance, my lord. And subsequently they decided.
This is no appeal in the eye of law till date.
Appeal
There
has
is a
been
delay. No, it is a delay for more than 1 year. Therefore, section 5 unless allowed, it is a non-est appeal in the eye of law. So therefore, your lordship kindly direct him to come by issuing a rule and explain and to comply. Subject to result of the appeal, we shall take care. But it is to be complied in his lordship's order to spirit.
Appeal is there, my lord.
Subject to
Mr. Falguni Bandyopadhyay, an advocate for alleged contender number 1, submits that. Who is 2? 2 is?
Who is the block development officer?
There was also direction upon him. You are representing 2. 2. Submits that. Alleged contempt number 1 submits that an appeal has been preferred against the order of this court passed in WPA 11718 of 2024. On which date?
Last week, my lord.
On give the date on such and such date. He seeks adjournment till the appeal is heard by the appellate court. Mr.
6th month. 6th August.
6th August. Mr. Vishwaru Biswas, learned advocate appearing for the applicant petitioner, submits that the order was passed on 20th March 2025. Pursuant to order passed by this court, the directions were communicated to the department. However, no steps were taken. within the stipulated period
বলছি
mentioned in the order. After filing of the contempt application, the appeal has been preferred at a belated stage. Only in order to deprive the applicant petitioner of his right as secured by the order passed in the writ petition. Such type of practices have been deprecated by the Honorable Supreme Court when an appeal is filed belatedly with a view to deprive the litigant who is suffering for non-compliance of the order of the court. He relies to buttress his contention, he relies on the decision of Honorable Supreme Court
2026 0 INSC 209 top first page.
2026 0 Supreme SC 225.
Kindly take the INSC because it's a Supreme Court website. 2026 0 INSC left hand side top 209.
It's all the same.
Yes, it is there.
2026 0 INSC 209. Israr Ahmed Khan versus Amarnath Prasad.
Paragraph 26 to 30. 27 to 30.
Moreover, there is no such stay granted by the appellate court. Stay against the order passed by this court granted by the appellate court. And as such, the order in the contempt is valid and subsisting and required to be complied with. In support of his contention, he relies on the decision of a coordinate bench of this court passed in 2016, 5 CHN Calcutta 624, Sheikh Abdul Matle versus RPS Khalon. Para. The record shows that consistently submissions were advanced before this court on behalf of the alleged contemnor number 1 that the office of the deputy secretary has fallen vacant. However, steps were being taken to comply the order of this court dated 20th March 2025. On 31st July 2026. Needless to mention that there was no submission on behalf of the alleged contemnors that any appeal was supposed to be filed. Be that as it may, more than 1 year has elapsed since the passing of the order. And after filing of the complaint application, submissions have been advanced on behalf of the contemnors, which has never been complied with, though it was informed to the court that necessary steps were being taken for compliance of the orders of this court. Sarah. What is the number of the appeal? Learned advocate for the alleged contemners to submit that an appeal has been filed against the order of this court. However, there is no such order of stay. Till the order is set aside or stayed by the appellate court, it remains valid and subsisting. This court finds substance in submission of Mr. Biswas, relying on Sheikh Abdul Matleb Supra. The Honorable Supreme Court, in Parakore, Israr Ahmed Supra or at this juncture, it will be profitable to reproduce the observation of Honorable Supreme Court in Israr Ahmed Supra, Ahmed Khan Supra as follows: 27 to 30. 27 to 30. Since from the materials on record, it is found that there is blatant non-compliance of the order of this court, let rule be issued against the contemners. Rule is made returnable. Date bolo. 2 সপ্তাহ পর 2 সপ্তাহ 24th August.
Contender number 1 retired from his service. Contender number 1 is retired. No, Budip Chandra
Rule be issued. Let's see.
Let him
We'll add
come.
contempt number 2 in the coming days. Rule is made returnable. Date to bolun 2 p.m.
I shall put the special messenger course by tomorrow.
The
Let them-
requisites be put in by the applicants
Yes, special messenger course by কালকের মধ্যে দিয়ে দাও।
within
Tomorrow, by tomorrow.
by tomorrow.
By tomorrow.
এটাকে আগে করে দিয়ে দেবে।
My lord, I'm so grateful to lords. Get
12টা দিয়ে।
13 to 17. I am indicating it to your lordship, I have requested my learned senior friend, Mr. Dhar, that, Justice Krishna Rao has fixed a matter at 12. Now, I was only beseeching if it kindly be taken up at 2 p.m. today, if it comments. I have requested my learned friend,
তাহলে কালকে রাখো।
Tomorrow, there is some difficulty. Day after tomorrow. Day after.
Tomorrow you make it.
I am not there tomorrow. Let me comment. I will not take much time. Since the matter is, I am yet to be called in courtroom number 25. Now, the issue which has fallen for consideration, the question that has been posed to me.
Yes.
Is, an observation made by the Honorable Supreme Court in Najma regarding, the particular madrasa in question. Now, please see Najma's judgment once.
এটা দাও না জাজমেন্ট আইটেম নাম্বার 1 এ হবে মনে হচ্ছে।
Now, please see paragraph. This is 2026 SCC online 1313. Reliance has been placed upon paragraph 23 from the original judgment. Rajkumar Bagh's appointment has been questioned by the Honorable Supreme Court. Now, my first submission to your lordship is Rajkumar Bagh and the petitioners here, Bimalendu Tung and others, they were similarly circumstanced. Now, the Honorable Supreme Court, when was approached in 2016, and the report filed thereat before the Honorable Supreme Court, took into consideration everything and accorded approval to all these persons who are now before your lordship.
Rajkumar Bagh and the petitioners are similarly circumstanced.
Rajkumar Bagh, as it appears, Rajkumar Bagh, please see, was appointed on 20th January 2016.
Yes.
And the petitioners before your lordship in December 2015.
1 month.
Now, this issue of ad hoc committee was alive even then. When the issue of ad hoc committee was alive then, and despite that, my lord, approval was accorded to their appointments, my lord, albeit provisionally, subject to result of SLP 666 or whatever, my lord, the 6661, my lord, it presupposes that, my lord, whatever cards that were before the Supreme Court or before the authorities, they had considered all those documents and thereafter, my lord, sought to accord approval. My answer to your lordship, appearing for the petitioners there, now, my lord, a settled position, my lord, legal question is, a settled position cannot be unsettled, and there is no, my lord, by change of law, my lord, a settled position cannot be unsettled. That is my legal argument. Because, my lord, please see, my lord, please see, my lord, please see, now, my lord, in Gimageria Welfare High Madrasa, that is the question which has cropped up. My lord, in the other writ petitions which are appearing before your lordship, my lord, this issue never fell for consideration. Because, my lord, Gigameria, one of the candidates of Gigameria was also being considered in Najma. We are Gigameria's original, my lord, persons who were accorded approval, albeit provisionally, in 2015-2016. The other writ petitioners in Tarikul Molla, my lord, or wherever I am appearing, my lord, those persons, they were not before the Supreme Court. Gigameria's one candidate, or apparently some of the other candidates, might have been before the Honorable Supreme Court. Now, my lord, my answer to your lordship is, a question has cropped up. The Supreme Court, while deciding Najma, has said day-to-day administration does not mean granting appointments or seeking approvals. Day-to-day administration does not envisage that. Now, my lord, though, my lord, a little out of context, because the issue before the Honorable Supreme Court in those matters are not exactly what is the issue here or before Najma. My lord, in St. Xavier's, Ahmedabad St. Xavier's College Society versus State of Gujarat, reported in 74-1 SCC 717, a nine-judge bench of the Honorable Supreme Court has laid down in paragraph 41 at page 750. 74-1 SCC 717. Has in paragraph 41 at page 750 laid down the law. My lord, please see 750, please. Has my lord very kindly got it. Autonomy in administration means right to administer effectively and to manage and conduct the affairs of the institution. The distinction is between a restriction on the right of administration and a regulation prescribing the manner of administration. The right of administration is day-to-day administration. The choice in the personnel of management is a part of the administration. Pausing here. So, my lord, day-to-day administration, my lord, I appearing for the petitioners as a advocate, as an officer of court, as your lordship's officer, cannot, my lord, request your lordship, my lord, but with folded hands, I would say that Najma did not consider this aspect of the matter. Najma, before the bench in Najma, St. Xavier's was neither cited nor was any argument made regarding this day-to-day administration part. But, my lord, their lordships in Najma has been pleased to hold that, my lord, the day-to-day administration perhaps does not envisage appointment. Now, my lord, then the other aspect is, my lord, when matters have attained finality. Bolo, 5 minutes. When matters have attained finality, my lord, insofar as according approvals are concerned, my lord, a settled position cannot be unsettled. Since attention of my lord has been invited to, my lord, paragraph 23 of Najma and has been sought to be contended that this is what Najma has held, I respectfully say that, my lord, once again, for the sake of prolixity, appearing for all the petitioners in all the matters, before Najma, no approved teacher was there. And Najma never considered the issue of approvals already granted. Najma never envisaged. On the contrary, my lord, Najma's last but one paragraph direction is, henceforth, these appointments have to be routed through the commission. Najma never contemplated that, my lord, whoever has been accorded approval in 2014 or 2015 or 2016 has to be reopened. Najma never said so. This is something like reading into the order passed by Najma. I adopt the submissions made by Mr. Shannal as well as Mr. Mojumdar appearing for the other petitioners. In Tarikul, that will be my submission. Because Najma, once again I say, my lord, a submission has been made from the bar that even teachers who had been accorded approval were before the committee. I respectfully say no. Before the committee constituted by the 2318 judgment, that is, my lord, Snehashish Giri, the committee that was constituted was directed to explore certain modalities. That was further enlarged by the Honorable Supreme Court while hearing Najma, arising out of the findings of that committee, saying that you please give us 10 names and give particulars of 10 candidates who according to you are best. Rajkumar was one of those candidates whose name was forwarded. Rajkumar Bagh was one of those candidates. Now, my lord, then I respectfully cite, my lord, 95 5 SCC 619 paragraphs 10 and 11 for the proposition.
This is, I don't make a much point, but 4 new judgments in.
Yes.
No. Now,
No, you
all I'm
indicate yourself.
requesting it, you have worked hard, do that, but please take note, this is, it becomes a very difficulty for the other sides also.
But I don't cite judgments. I am citing the legal proposition by only suggesting to your lordship there are settled position. My lord, these teachers, whoever is before your lordship today, they have disclosed all their cards. My lord, I am covered by, my lord, the judgment of H.S. Mudhol, which says, my lord, a settled position, someone is working for 10 years. Today, my lord, the eligibility criteria for appointment is X. Tomorrow it becomes X plus Y. Will you examine X and say that X does not have? Well, that was never under contemplation. That was never under contemplation. My lord, if my learned friend takes objection, I am, my lord, indicating the paragraphs and handing over. Let him distinguish, my lord. I am open to that. But only one thing, my lord, there cannot ordinarily, my lord, since this argument has been professed, not at the instance of the state, but at the instance of the commission. My lord, I am tempted to show your lordship or cite before your lordship, not judgments maybe, but legal propositions. The legal proposition is a settled position cannot be unsettled. Then, my lord, another legal proposition is the binding effect of a judgment or the ratio decidendi of a particular judgment even if it is overruled, it does not dilute whatever has already occasioned by dint of that judgment. My lord, to give your lordship examples, my lord, previously the law, as in Uma Devi, some law was laid down. My lord, a division bench of the Honorable Supreme Court wanted to dilute that proposition. Subsequently, my lord, an official liquidator, my lord, Puran Chand Pandey, wanted to dilute. If I am not mistaken, my lord, Mr. Dhar will kindly correct me. Puran Chand Pandey sought to dilute Uma Devi's principles. Overruling Puran Chand Pandey, official liquidator, once again said the law as being what the law should be in the light of Uma Devi. But, my lord, whatever action in the light of Puran Chand Pandey has been taken was never unsettled. Why I am saying this? Because, my lord, in the 2020 judgment, my lord, much water has flown down. Paragraph 64 of the original Sheikh Muhammad Rafiq's judgment has been categorically, my lord, distinguished in both Snehashish Giri as well as in Nazma. And therefore, the Supreme Court has laid down certain parameters. The candidates in Nazma did not fulfill those parameters. The matter has been put to rest. Those candidates have not been favored with whatever they were seeking. But that does not envisage a situation whereby the settled position had to be unsettled. Now, my lord, I am also raising this legal principle that a person's appointment cannot be disturbed after a decade when no fault is attributable to him. He had merely filed a contempt application or an IEA in the proceedings before the Supreme Court. All these persons did. My clients in the first matter, Mr. Sohel's client in these matters, Mr. Robrotos Mojumdar's clients, all of were before the Supreme Court by way of IAs. The state at that point of time took a stand. Yes, they should be paid their salary. They should be accorded approvals. Yes, it was provisional. Provisional subject to SLP. And the SLP ultimately on dismissing the, or rather, on setting aside the judgment of the Honorable Division Bench, did not ever disturb the position that has already been done. Paragraph 64, the interpretation in Nazma or, in Snehashish, according to my humble submission, the Supreme Court was considering unapproved teachers or unpaid teachers, not persons who have already got their salaries and who have already been benefited by approvals.
Rajkumar Bagh was appointed.
Rajkumar Bagh was appointed. The Supreme Court felt that an unaided managing committee had approved it, had sent it for approval. But that unaided issue never fell for consideration. Only in Rajkumar, the Supreme Court has laid down certain parameters. That doesn't mean, when approvals were accorded to persons who were appointed in December in the year 2016, November, October, when they were accorded approval, those approvals have been touched by any stretch of imagination. Rajkumar Bagh was not getting salary. He had never been approved. There is a distinction.
Just bifurcating somehow from what you have submitted, if Rajkumar Bagh would have received the salary,
then he wouldn't have been before the
he
Supreme Court.
wouldn't have to file a contempt
He
application.
wouldn't have been before the Supreme Court.
Correct.
Yes.
Now the madrasa which was not valid for Rajkumar Bagh cannot be, sorry, invalid for Rajkumar Bagh cannot be valid for the petitioners.
Milord, I respectfully say that
At the same time, these petitioners you say have been approved and granted salary. And an affidavit of compliance also filed before the Honorable Supreme Court that 9th February was followed. But one, you started with that Rajkumar Bagh and the petitioners are similarly circumstanced. Only distinction is Rajkumar did not receive the salary, whereas the other.
Milord, I cannot say something beyond what the records say. Because Rajkumar Bagh's finding is January 2016 appointment.
If a committee which was invalid for Rajkumar cannot be valid for the
Milord, that is, my answer is the committee's issue was never an issue. Milord, prior to the Honorable Supreme Court by an order in Najma saying, or even in Snehashish Giri, when the points were laid down, one of the parameters that was directed to be considered as to whether the managing committee was valid. Prior thereto, prior to 2023, this issue of ad hoc managing committee or temporary managing committee was never a consideration either in this Muhammad Rafiq or in any subsequent judicial pronouncements. Now, Milord, subsequent change of law cannot unsettle of the previous cases. That is also my submission. Your Lordship may kindly note it down. Milord, if our judicial precedent is insisted, Milord, we can give it. But Milord, since he is raising an issue, he has a right to raise it. Milord, I am not saying anything. I am saying, Milord, a subsequent change of law cannot unsettle the previous cases. Milord, for an immediate reference, Milord, a 3-judge bench of the Honorable Supreme Court in 2024, 7 SCC 433 has laid down that law. 433. 2024, volume 7 SCC 433, paragraphs 42 and 47. 95 I am also showing, 42 and 47.
95,
5 SCC 619, paragraphs 10 and 11. 10, 11. 619. And Milord,
no, this one 2024.
2024 S7 SCC 42 and 47. (42 and 47). When a proposition is subsequent change of law cannot unsettle the previous cases. And Milord, a submission has been made that the law laid down in Snehashish is 141. Milord, Mr. Mujumdar, I distinctly remember, has argued that it is not under 141, it is under 142. And he has shown your Lordship the relevant paragraph whereby Justice Ravindran, the author of Snehashish Giri, Milord, as his Lordship then was, Milord, was pleased to lay down that therefore in our exercise of powers under 142, not 141. So, Milord, if a judgment has been delivered under 142, it is in the special facts for the ends of justice. It cannot be, Milord, said to be a 141 judgment. My clerk is looking at me. The battle is going on here. And Milord, last proposition, Milord, it has been argued. It has been argued that, Milord, in all the matters, as a matter of course, that, Milord, they have a right to re-examine this entire issue, being emboldened by the observations of Nazma, which according to them has laid down some law. My lord, in NASMA, orders declining approvals by the 3-member committee was under challenge. Order declining, your lordship may record, these were all, most of them, if not all of them, were Article 32 petitions. They were not, my lord, a proceeding arising or an offshoot of Snehashish. Snehashish, under 142, directed constitution of a committee. The committee, in its prudence, considered more than 500 teachers and non-teaching staff. And out of those 500, 49 writ petitions were carried to the Honorable Supreme Court in various, and the total number, as would appear from NASMA's first 2-3 paragraphs, it was 350 or more or less. So who were before? Those who had declined.
500 were declined.
500, but all 500 did not travel there.
That's true.
49 writ petitions were carried, and those writ petitions, a writ petition is not continuation of any proceeding. It's an independent proceeding. It's not continuation of a previous Rafiq. In a writ petition, if I cite judgments, that doesn't mean, while arguing a writ petition, I am carrying that judgment to your lordship's court for an independent examination. I am citing, your lordship may decide against, your lordship may. That is what precisely happened in NASMA. Because NASMA, since there were a lot of confusion, their lordships felt that you give us 10 test cases and we will examine this on these parameters. There was a lead counsel also appointed. Not lead counsel, it is nodal counsel. Nodal counsel was appointed in Supreme Court. The nodal counsel collected all the papers. Mr. Sohail gave one, my advocate on record gave one, and those were considered, and independently the Supreme Court felt that these persons cannot be given, and as a consequence, the entire bunch cannot be given. The matter ends there. Since writ petitions have been dismissed, since these matters are not entertained, commission is directed to now do it. But the Supreme Court never said, you reopen all these cases, I shall examine. Then the Supreme Court, it would have been alive, had it been alive to that situation, because when the Supreme Court was informed, paragraph 64 of Rafiq has to be read in the context of persons appointed but yet to be approved. And those persons carried Snehashish, those persons carried NASMA. Authorities cannot be permitted to do what is not expressly permitted by law. A judicial dictum, our High Court has very long back, my learned senior friend is very well aware, in Moniruddin Bapari's case, 40 CWN page 17 is the citation, I don't have it just now. It says, an individual can do everything unless there is a prohibition in law. But a statutory authority can do everything which is permissible by law. There was no express permission, express authority conferred on the authorities in NASMA to unsettle a settled position. My respectful submission, appearing not only for these petitions, but all the petitions, kindly, respectfully, I am submitting that a settled position was never directed to be unsettled by the Honorable Supreme Court. And this endeavor to reopen by the Director of Madrasa Education, who in 2016 accorded approval, is a complete arbitrary and erroneous exercise of power. It is bereft of any jurisdiction. It is a nullity in law. And I request your lordship to kindly interfere. Another limb of submissions that have been made is on the issue of show cause. It's not a question of, a show cause can always be challenged. Mr. Majumdar has perhaps addressed your lordship on that. If it is inherently lacking in jurisdiction, there is an inherent lack. This entire proceedings stem, The first sentence is in accordance or in pursuance of the Nazma's judgment. It does not stem from Nazma's judgment. It does not, my lord, emanate from Nazma, whatever is being sought to be done today. So, my lord, I conclude, appearing for all the petitioners, my lord, that, my lord, your lordship will kindly interfere and, my lord, set the ball to rest. And I am praying for an appropriate interim order, my lord, in all these proceedings. Not necessarily the one, my lord, all these proceedings, my lord. I think, my lord, Mr. Mujumdar is also here. I think he is going to say the same thing, but we are praying for an interference.
Ask your junior to
Prepare
make
a note.
compilation and give the
My lord,
paragraphs along
Mr. Singh is going to do it.
Or you also, you ask your junior to prepare that, whatever you have cited.
My lord, I would only.
If required, you can collect this from the court officer and make that compilation.
I think that would be better because the lordship must have it somewhere.
এইটা শুধু এই নোটটাকে বার করে নেবেন, বাকিটাও দিয়ে দেন।
Should we make an index?
My lord, the only
The citation and the paragraph number cite, yes.
my lord, the only thing is, kindly, the surreptitious attempt on the part of the state to unearth a settled position, my lord, has to be on the touchstone of Article 14 and 16. None of these appointments. My lord, another thing, my lord, which I perhaps missed. My lord, in the reports, your lordship will be pleased to see that out of 10 teachers, 8 teachers were accorded approval, 2 were not, presupposing that there was some conscious application of mind then. In the compliance report. It is not that, my lord, everyone was accorded favors. Had it been so, then today Rajkumar wouldn't have been, Rajkumar wouldn't have been in the Supreme Court. Rajkumar was never accorded. For whatsoever reason. The Supreme Court now has gone into the issue of committee. The Supreme Court then never went into that question. That question itself was, my lord, if I may say so with greatest of respect, my lord, it was Justice Dotto's, my lord, that question. This I am saying, because in Rafiq, my lord, St. Xavier's was cited.
He was there in Snehashish also. Justice Dotto was
Dotto
there.
was there.
also in
Yes, he was the, my lord,
same bench.
no, Ravindranath, Justice second Justice Sharma mone hai. Nazmata Justice Dotto presiding judge.
That's the thing in both cases.
Justice Ravindra and
My lord, I would be only those 4 or 5
My lord, I am
judgments. But before I say anything,
I am the managing committee.
I'm sorry.
Please, I must appreciate for his. It was an excellent argument. So I would begin with appreciation of my learned friend. It was, in fact, I was listening. I liked his submissions. Way more.
My lord,
Not every time I appreciate.
it's a blessing. It's always a blessing.
Every time he does not say so.
On a lighter vein, this itself warrants an interim order, right?
But when he begins with this, my lord,
Yes, yes.
My lord, your lordship will kindly not hear this gentleman. First, your lordship will issue a mandamus for a different purpose. I shall tell your lordship one day.
Okay.
But I would quickly go to exact judgment and why, my lord.
But
this is
before
not-
that, I am for the managing committee. I have to say something.
You have made your
But they
submission.
have, you have already completed your submission.
Yes, but in reply, I have to say something. In reply, I have to say something.
Well, it would be better that if I distinguish thereafter if my learned friend says. That would be better. Just give me, it is only just 4 judgments. Now,
এটা তিন একবার আরেকবার
well, I will just say the proposition.
One, Mr. Mojumdar has referred to
Well, I'm-
2017.
Well, I'm first is the Girish Kumar judgment, which is 2017-14 SSC 809.
Yes.
Now, the proposition was that Article 142 is not binding. Article 141 is binding. Snehashish is Article 142. That is the proposition. I completely agree with this. But I only add 2 points. Point number 1 is this. In Snehashish, because it is in Snehashish, now Lordship may kindly see, the proposition is correct that 142 is for complete justice. Now 142 is for complete justice for what? For a particular subject, for a lease, which started in Rafiq, continued in Snehashish, and ultimately Snehashish is 142, not the Najma. Najma is 141. So I say that in Snehashish, even if I accept the proposition that it is 142, today the case before your lordship is not a case of Maharashtra or Bihar or any other state. It is the same respondents, it is the same subject matter, and the subject matter in the judgment itself, why it is otherwise. Kindly have a look at Najma 5D. Answer is given in Najma itself. 5D. Page number 4.
Yes.
Now, kindly take my lord from the paragraph D, from the bottom, 1 to 7th line, starting from section 11. Now, this is section 11(1) that any appointment of a teacher made on or after the commencement of the MSc Act in violation thereof would have no effect in law, and section 12 mandated the penalty that could visit the managing committee, the ad hoc committee, or the administrator, such and such. So, the context of Article 42, in this case, why it is 100% binding? A, because it is the same subject matter. B, it is because of a situation. Section 11 says that under the Act, it is the commission only. By virtue of 11, if appointment is given by anybody, then it will be illegal. That is recognized by the Honorable Supreme Court. But still there is a window, and that window requires 2 notifications. If that is followed, that is permissible. So therefore, to contain that, Snehashish is Article 142, therefore it is not binding to us. That can be only said by some people who are not relying on something arising out of Rafiq. Kindly see, my lord, this is the paradox. On one hand, their lifeline, their oxygen is 64 or Rafiq. On the other hand, that Rafiq 64 under Article 142, same subject matter, same respondents, same lease, has been diluted through the committee. So therefore, no question of a precedent. It's a question of in the same matter. Rafiq is exactly the Snehashish. So therefore, there is no requirement for this case to have anything Article 141, where Article 142 for this subject matter is clearly there by the Honorable Supreme Court. So therefore, my answer is this. Yes, I agree with the proposition. Had it been a case of in Maharashtra, this judgment is shown, Snehashish's judgment, their counsel can take the point that, look, this judgment is not binding on us. But they cannot take this point because it was the same state, it was the same respondents, and it is the power of the Supreme Court under Article 142 to do complete justice. Now, complete justice equals to committee here. They cannot ignore it. Some other states, some other situations, they can, but they cannot because of the same respondent. So therefore, it is binding.
Yes.
Just one factual aspects. When paragraph 17 was written, was held by the Honorable Supreme Court. Can you have a look at 17?
Najma.
Yes, Najma.
Yes.
17, Lordship has read. Now 17, can we assume in Snehashish, one of the honorable judges, being the Honorable Justice Dipankar Datta, was there. So therefore, whether it is whisper, whether it is a standing on the sand or not, the Honorable Court, particularly the concerned judge, was aware of. Despite that, paragraph 64 was taken up in Najma, and paragraph 64, when sought to be relied by one Mr. Roy, just like all my learned friends, the Honorable Supreme Court, comprised of one of the Honorable Justice, Justice Dotto, who was also there in Snehashish, clearly held relying on 64 is standing on the sand. Now, this is not a curative petition, neither it is a review before the Honorable Supreme Court.
Yes.
Right, wrong, immaterial. Once Najma says 64 equals to standing on the sand, I don't think I have to use or I have to have my own innovative thing. No requirement. That is the end of the matter. That can only be reopened by the Honorable Supreme Court. So therefore, this proposition of 141 is absolutely, if I can use the word, irrelevant. Now, next judgment, my lord, that is the Mehboob. It is 2004 2 SCC 362, paragraph 20. 12. In Mehboob judgment, the
Yes.
point that, let's can you take that?
Mehboob, yes.
In Mehboob, my lord, my learned friend relied on paragraph 12, last portion. So precisely, it says that a decision is available as a precedent. Kindly mark, my lord, the word precedent. Why, my lord, I want that today it is a case of under Article 142 directly applicable for this state and these all respondents and this situation. That's a lease. So therefore, it cannot be tinkered with. It's not for a different. And second is, a judgment should be understood. Sorry.
Yes.
A judgment should be understood in the light of facts of that case, and no more should be read into it than what it actually says. It is neither desirable nor permissible to pick out a word or a sentence from the judgment of this court. Well, absolutely right. Proposition is right. No one is trying to say, neither I am trying to say that judgment should be read out of the context. What is the context? The context is, after 2008, because of Section 11, as acknowledged in Najma, nobody can give an appointment. That is illegal. then how the appointment could be given? Because of following of some other notifications in that window. So that is the context. In that context, Najma is the point of law which has been decided by the Honorable Supreme Court. Thereby, this is clearly, my lord, binding, and more so, the respondents remain the same. My learned friends, lastly at the end, Mr. Bhattacharya referred about Article 14. Today, if some persons' appointment are found to be illegal for X, Y, Z reasons, nobody can say that.
I take your lordship's kindly.
Nobody can say that I am exceptional. He has to complete the sentence. Why you are exceptional? Their entire argument, I am exceptional because of two things. Thing number one, 64, and thing number two, approval. Approval was provisional, clearly saying we are reserving the right to verify, page 153. And 64, diluted, committee, and ultimately point of law in Najma. So both, it is like starting a journey. After a half journey, which they have enjoyed it, they want to remember only that part of the journey. But there is a second half of the journey which happened. That also needs to be recognized. So this recognition, that to say that it started with Rafiq and ended with Rafiq, will be out of context. So therefore, again, my lord, the proposition is not wrong, but this proposition is not applicable in this case because the entire submission has been in the context, and the context being, how can you make an appointment because of section 11? Answer is yes, I can, because of that window and then notification 1 and 2. Third judgment was Abdul. This was by Mr. Shannal, our High Court judgment on the point of show cause. This is paragraph page 8.
Just 2012, yes.
Yes.
Page number?
My lord, the page number 11. I will simply show 2 lines from this judgment and 1 page from the writ petitions. I think I don't have to distinguish. A person, Lordship has got page 11.
Yes.
From right, I am reading. A person cannot be required to undergo one inquiry after another on the same allegation. So precisely what they want to say, that once it is approved, therefore they shouldn't be asked to come up with the original and etc. again. That's the proposition.
I have not got that line.
Sorry, it is at page number 11.
11.
Just the first line. First line, right hand side. A person.
So the top starts with cannot be required to
No,
undergo.
the top starts with the same. Let me see whether I am wrong. Maybe it's possible that maybe I have taken SCC online, but in SCC online, before it gets a volume, it might, may I give the paragraph?
21, 22. Is it 20?
Well, it might be page.
A person, yes.
Lordship has got
It is
person.
paragraph 22.
Paragraph 22.
Third
yes,
line
correct.
starts with a person cannot
Right.
be required.
Yes. A
Yes.
person cannot be required to undergo one inquiry after another. Now, I won't be saying anything. I will only be showing. Kindly take page 153 of Tarikul, side by side.
Okay. Yes.
153, the last paragraph. Before I place it, 153 was never challenged by them. So they have accepted. If they have accepted 153, that means they have accepted now what I would be reading. The release of salary for the period for which they have performed their duties will continue and is subject to further orders of the Honorable Supreme Court in this respect. Kindly mark, in this respect, since the eligibility of the above named staff to their engagement in madrasa could not be determined due to the ongoing proceedings of the Supreme Court, it shall not be a precedent for any case before any madrasa and will also not prejudice the state from examining the issue subsequently. Therefore, 153 preserved the right to examine further, subject to Honorable Supreme Court. So, therefore, this judgment of Abdul is absolutely not applicable in this case, because in this case 153, which they are relying on, that itself reserved the permissibility for verification. And that was never challenged.
Yes.
In this case, in my understanding, preservation of verification coupled with no challenge of such preservation, and then this entire, that according to me, that kills the basic pattern of the argument in this judgment, because the judgment says that in case of no jurisdiction, show cause can be challenged, and once an inquiry has been done, there should not be a further inquiry. It was not in the context of, in the first inquiry itself, there was a preservation that for XYZ reasons, I am not doing it, but I will do it subsequently. That was absent. So that absence of fact and the presence of a fact by virtue of their earlier judgment, that a judgment should be relied when the facts are similar. It cannot be picked up and there. My lord, it's not applicable. The next judgment is today they have relied 1974 1 SCC 717 paragraph 41.
Yes.
My lord, 41 has been placed only for the purpose of diluting what has factually been decided by the Honorable Supreme Court. The Honorable Supreme Court, after seeing fact and laws, found in XYZ madrasas, the particular ad hoc managing committee, they had no competency, no right to make an appointment. Now, for the time being, even if it is, let us for the time being assuming this is not a correct proposition of law, can your lordship say so? Can your lordship say that no, the 23B, the Honorable Supreme Court was incorrect? So therefore, to invite your lordship that see paragraph 41 of another judgment and thereby dilute a factual finding by the Honorable Supreme Court is not permissible. So paragraph 41, they are seeking dilution of a factual finding by the Honorable Supreme Court, which cannot be, in my respectful submission, the High Court, right, wrong, immaterial, High Court cannot enter into that. Yes, there are ways. Review is permissible, curative petition is permissible, but not in a writ petition. That questions cannot be reopened. Nobody can say that this point was not taken by the Honorable Supreme Court, that because our judicial system is not built on that. That's the finality is attached. One, the Honorable Supreme Court has held so. So 41 does not dilute the factual finding in paragraph 23 onwards.
41 is a minority opinion. Who that is out of
My lord, then 2024 7 SSC 433 today, Mr. Bhattacharya's.
Yes.
24 7 SSC, my lord, paragraph 42. Now this is, may I just read? If subsequent change of law is allowed, kindly mark, subsequent change of law is allowed as a valid ground for condonation of delay, it would open a Pandora's box. Firstly, this is not a subsequent change of law. It is a decision of the Honorable Supreme Court in respect of one subject matter in one state in respect of same respondents. So therefore,
Yes.
there is no new legislation. Lordship may also see the, if I can say, that acknowledgement of the Honorable Supreme Court about do's and don'ts. The Honorable Supreme Court are absolutely aware of the fundamental proposition of law that once something is decided, let's say in the Rafiq, usually the Honorable Supreme Court cannot tinker with it, cannot change it. That is the reason while changing 64, Article 142 has been used. That's the acknowledgement. That's the correctness. That on one hand, the Honorable Supreme Court is acknowledging, yes, in Rafiq this has been said. But on the other hand, because of some reasons, the Honorable Supreme Court failed. That no, it was not probably right. Something has to be done about 64. And that's why what to do? We have the power under Article 142. Therefore, we exercise 142 and we change 64. So this is absolutely in sync.
Okay.
And therefore, this proposition of and this 42, that it would open a Pandora's box.
Yes.
Now, Pandora's box was opened by the Honorable Supreme Court in Snehashish. So it is not that it was realized. At that juncture, that might have been a point to be decided, but it is today, it is no more. That Pandora's box was decided and parameters were fixed, and thereafter in Najma, clear-cut law has been found. After holding in 17, you can't stand on 64 because this is standing on the sand. So therefore, paragraph 42 is not applicable. In fact, there is a very easy way also saying also that moreover, this is also in a case of a condonation of delay and others, but that's in addition to that. My lord, the last judgment is 1995, 5 SCC 619 today.
Yes.
Well, this I would answer coupled with another point which they also said, that there is no such statute under which this notice has been given. Lordship, may kindly look at very interesting thing, that they are relying on two things, paragraph 64 and the approval. Now, approval is coming under what statute? Supreme Court has in D, I have clearly held, after the Madrasa Service Commission Act, nobody can make any appointment, no recommendation. So it would be illegal, and there can be a penalty for that. So therefore, if a question of law comes, statute comes, it is only the commission and commission alone can do. So therefore, whatever has been done or permissible to be done, it's an exception. And that exception otherwise is contrary to law, requires to confirm certain parameters, which is notification 1, notification 2. Therefore, I was thinking this way, if their very birth is not on the basis of a statute, because page 153 is not a statute, just an approval. How can they say that for our death, it has to be on the basis of a statute? If somebody is born based off a statute, he can say that my death has to be also on the basis of a statute. And it is the same thing, that because statute itself is against them. So therefore, the entire context is, do I fall within the exception category of window? So therefore, window is never a statute, they knew it. If window was never a statute which gave them birth, it does not suit their mouth to say that in the show cause, no statute has been referred. So to say so, they have to show the birth is by statute, then you can claim death has to be by statute. This, though it is not a death, it is, I don't have a better metaphor, because it's not a death, definitely. It's not a death. It's maybe a
Termination.
No, I'm using the death as a, not as a death in that sense, as a metaphor, because birth is like appointment, just a metaphor. Birth equals to appointment.
Birth in the cadre, death in the cadre.
Yes, yes. I think that is precisely. So in the birth, I will borrow your lordships. I couldn't, that's a better expression. If birth in the cadre is not on the basis of a statute, and the statute says that it is the commission and commission alone, then they cannot make a ground that my death in the cadre has to be on the basis of statute, because this is again, it doesn't go together.
Okay.
Well, I borrow your lordships this expression as my expression.
Yes.
This was the last, so therefore I would not say anything excepting this for that. And these are my
1990. That's all.
No, I am for the managing committee. No, my lord, all these managing committee in respect of 4 madrasa are running by virtue of the honorable court's order. They are, my lord, dealing with the administration, the recruitment, all other things. Now, the Gimagadia ad hoc committee has given certain appointment who are the petitioner in connection with the Ropik cases, has given some appointment who are the petitioner in Najma Khatun's case. Now, when the matter was dealt with, in so far the Ropik case is concerned, what the Honorable Court has said, that is very important. Honorable Court has said by virtue of an interim order that you check these papers and subject to the satisfaction of the eligibility to release the salary. Now, my lord, after entire checking the records of the petitioners in that writ petitions, in SLP petition, they have given the approval provisionally subject to the result of the SLP. Approval has been given, compliance report has been given. Therefore, all papers have been checked up, verified. Therefore, approval has been given. Now, that is subject to the, my lord, the final result of the appeal, SLP, and in the SLP final judgment also, all these appointments deemed to be approved for all purposes. Therefore, this judgment has not been touched. This particular so far the approval is concerned, has not been touched by the judgment of the Najma Khan. Because this is the judicial precedence. Because the coordinate bench in the same court should have followed the judgment of the earlier coordinate bench. They cannot make any comments over the earlier coordinate judgment. Here the same thing is happening. There the second coordinate bench, this is Najma Khatun judgment, regarding the approval of the Ropik's case, they have not been touched. Nothing has been whispered in this judgment. Therefore, when this judgment has been given a finalization, this is binding upon all the court under Article 141. And my lord, see, when my lord, the Honorable High Court has also, my lord, to follow the judgment which has been finalized. And so far the Najma Khatun judgment is concerned, my lord, when, my lord, this issue has not been reopened, because that issue cannot be reopened when it has been settled. Because in Najma Khatun judgment, so far the approval is concerned, that has not been reopened, nothing of this sort. And so far the ad hoc committee is concerned, that has not been, this issue was not there in the Ropik's case. Therefore, if that be so, then this judgment of the Ropik's case is binding. One judgment I put, only one judgment.
Again, I have to go back.
I am reading that judgment. Only I am reading the judgment. 2020, my lord, 2002, volume 2, Supreme Court cases 420, paragraph 9. 2002, volume 2, Supreme Court cases 420.
420.
420. 420. Paragraph 9, I am reading that. I am reading that. It is impermissible for the High Court to overrule the decision of the Appeals Court on the ground that the Supreme Court laid down the legal position without considering any other point. It is not only a matter of discipline for the High Court in India, it is the mandate of the Constitution as provided in Article 141 that the law declared by the Supreme Court shall be binding on all courts within the territory of India. It was pointed out by the court in Anil Kumar Neotia versus Union of India that the High Court cannot question the correctness of the decision of the Supreme Court, even though the point sought before the High Court was not considered by the Supreme Court. Therefore, my submission to that extent, when the judgment has been finalized so far the approval is concerned, and that has not been touched by the Najma Khatun judgment. Therefore, this is finalized and that is binding upon the High Court. And the High Court cannot correct the judgment of the Honorable Supreme Court. But this is my only submission.
I have one sentence. I am actually relying on 9. High Court, it is impermissible for the High Court to overrule the decision of the Apex Court. I am relying on that. Tawfiq can be changed, diluted by the Supreme Court, which has been done. High Court cannot. I'm very.
Tawfiq has been finalized. That has been touched in Najma Khatun judgment.
I'm indebted that paragraph 9. What I said while my submission, he has supplied with the judgment.
এইবারে ওটাকে দিয়ে এটাকে কম্পাইলেশন করবে
And deeply obliged for.
Yes.
When we as a councils, we have a patient hearing and a point counterpoint in a very sensible manner. We not only love it, these are the things I think we cherish for the institutions. Deeply obliged.
Thank you. Awesome. Mr. Vishwaru Bhattacharya for the petitioners in item numbers 13,
14, 16. 13, 14 and 16.
13, 14 and 16. They can even WPA number to them. Who concludes his reply? Learned advocates for we can take all the matters analogously.
Yes.
It analogous course. All the matters, similar issues are involved, and the matters are taken up analogously. Learned advocates representing the commission, Mr. Pratik Dhar, learned senior advocate appearing for the commission in all the writ petitions, submits that since the matter pertains to a point of law, the commission would not use any affidavit in opposition. Similar submission is also advanced on behalf of learned advocates representing the state in respective writ petitions. Accordingly, the hearing is concluded and the judgment is reserved and made CAV. Ask your juniors to make that, huh? Devnath Babu, ওনাকে প্রোভাইড করে দিন, ওরা করে কম্পাইল করে দিয়ে দেবেন, এটা ঠিক আছে। Give the citation, paragraph numbers of the writ petitions which you are reading.
Back the judgments and keep it in a compile.
Yes. এটা দেবেন না, এটাই থাকবে।
Grateful dear Lord.
Thank you. Thank you.
मुझे मिस এই মোদির
May I leave to mention, my lord, leave to file this on the SOP matter. My lord, the matter is ready.
Item 11, I am for the petitioner. Lordship, I am for the respondent number 3.
Contempt.
I am for the respondent number 3, Lordship.
Respondent.
Pradhan. Panchayat Pradhan.
You contemptor.
Yes. Lordship, the notice which have been served, that is received by the Panchayat Secretary. Panchayat Pradhan have not received the notice. So that's why there is some miscommunication. After coming
Notice of contempt.
contempt, I have not got the petition only, Lordship.
Through court, in her name it was sent. Your lordship passed various direction. Read, she has refused. Order, she has refused, my lord. Refusal is
Lord
service.
Lordship, Panchayat Secretary have received all the notices. She had no idea. She had no idea of this notice, Lordship. After coming to the knowledge, respondent number 3 is right now is saying that I don't have any idea. After coming to the knowledge of
Which
this
idea?
matter
Which idea?
of the order.
Which order?
Speed post I have, my lord.
Uh,
By her.
no, not that order. Last order which is have been given by this court.
Where is the alleged contemptor?
Where is the LSP?
If he doesn't have it, if he doesn't receive the copy of the order, how do you expect
Just-
that she will have knowledge?
Lordship, I have just only got from Sharthuk only one petition, WPA number 19117 of 2024.
Order passed on 29 July. When this order was
No
communicated,
copies I have not got. That this also I have.
That is why not got.
This is also I've got from the Sharthuk, my lordship.
Well, I have annexed everything. Kindly have a look in. Well, annexed C, my lord. Page 39.
page 39.
Yes, page 39, my lord, refused. That original is also with me, my lord. Page 39, refused. Before that, my lord, it starts from Annexure B, page 28, my lord. The letter, what communicated by me, which was communicated by me on page 28, my lord, it starts 7/8/25. That was the communication letter. My lord, speed post I have given. Order was communicated. Thereafter, my lord, everything was refused. All the
Then
document I have. Page 39, my lord, refusal.
refuse.
Thereafter, my lord, both the my lord, envelope, the Xerox copy of the cover,
Then
page 39 and page 44.
Lordship, but Pradhan is saying that she don't have any idea.
Pradhan can say many things.
But right now she is complying
The
with the
records
order.
is saying that you have refused. Now we cannot say that I don't know.
Pardon me, Lordship. Right now, Lordship, she is complying with the order. Which
How?
passed.
Notice have been issued. Notice of hearing has been issued.
Notice of hearing on 20th July have been issued.
You yourself has not gone through the orders. There was a notice for hearing, then calling the parties and also
20th
making
July.
an inspection. All this has been done.
20th July একটা date ছিল তো। আসার জন্য। Order ছিল তো।
You have caused inspection.
No, my lord, nothing was done. No notice was
আপনাকে
served.
জিজ্ঞাসা করছি।
I'm asking you, not her. You find out from your client.
Inspection কি
inspection
হয়েছে?
হয়েছিল না আমাকে যে
Where is the copy of the notice being given to the parties?
আমাদের কোনো copy but we have not been served any notice or nothing else.
Lordship, inspection.
What is this? বাসন্তী ঠাকুর প্রধান, আপনার নাম বাসন্তী ঠাকুর? প্রধান রাধানগর গ্রাম পঞ্চায়েত Bankura, alleged contemner is present in court.
Okay. I mean,
Any report is there, my lord, kindly let me to see.
video
Regarding successor inquiry report of
video. Lordship, through video, Lordship, through video, the report have been inquired.
file a compliance report. Affidavit of compliance, shall we? Then an advocate for the alleged contemner submits
Lordship, we
that-
complied with the
submits
notice.
that steps have already been taken for complying the order of this court. She seeks to file affidavit of compliance. Let such affidavit of compliance be filed on the returnable date. Advance copy be served upon the learned advocate for the applicant petitioner. File an affidavit of compliance annexing all the documents, what steps have been taken and whether it has been forwarded to the SG or not. After 2 weeks.
কি হবে আমাদের আচ্ছা আমি
By mail ও পাঠানো হয়েছে।
রিটার্নেবল ডেট মাই লর্ড
Number appearance of the alleged contemner is dispensed with for the time being. Let her come up with affidavit of compliance annexing all the documents and the steps taken. Thereafter, we go through that, we'll find out. It's on. After 2 weeks, this will appear. File an affidavit of compliance.
Grateful, Lordship.
Oh, এটা নিয়ে নিন।
সাড়ে তিনটে থেকে
I have put the pictures there. I have mentioned 3 matters analogously here, but 1 matter not appearing in this. The item number WPA number 3109 of 2025. Inquired from the court officers that the requisition has been sent, the file is not here.
396, 397, all are same.
All are same. The three, by Usti was included, but Usti is bearing the requisition, they are claiming.
But the subject matter is same.
But no.
The
Kindly listen.
Achha.
But they are claiming adding date pay of 3,600 from 2006. I am claiming date pay 3,600 from 1st of August 2019. That has been accepted by the government. I am praying, let the government evidently may be accepted. Nothing more. The Usti stage is different. What my
my lord, in this matter, your lordship.
The item number 697 does not relate to a category scale. It relates to, my lord, for giving notional effect in accordance with 2009 ROPA rules of the notification issued in the year 2019.
Okay, we come back to you, Mr. Banerjee. 696 will be heard along with which report?
My lord, your lordship, if your lordship kindly go through, kindly go through 5th September 2024, my lord, the order dated. My lord, in that order, my lord, the learned advocate appearing for the.
File is not here. What are you saying? That file is
in
not
in writ petition number WPA 20328.
That was not listed.
Oh, my lord, kindly see the order dated, my lord, passed in this matter, my lord, in 696. That is, my lord, 20328.
Yes.
My lord, in this writ petition, kindly go through the, my lord, say order dated 5th September, my lord. 12th September, it is, my lord. 12th September. One order is there, my lord. Where, my lord, the learned advocate for the state appearing, my lord, he, my lord, made the submission before this honorable court, my lord, that this order, this matter is related to this matter. Therefore, I made the, my lord, submission.
Well, this is not
My lord,
correct.
Dharan, I don't know whether it is correct or this is
Yes,
the submission made by the in your presence. This has been submission was made several times. And my lord, my humble submission before your lordship, my lord, in this matter, my lord, I have filed my report.
In which?
In this matter, in 696.
Yes.
And my lord, to that, my lord, against that, my lord, report, my learned friend has filed the exception.
Yes.
Now the matter is ready for hearing, lordship. And my lord, if my lord, the next item is not tell you with this matter, then this matter should be maybe heard by your lordship.
yes, that
I
is-
don't have any objection. But this was the submission at point of time made by the learned state advocate. Therefore, I have prayed before your lordship on the last occasion that this matter may be tagged with this matter.
Well, that is why I am saying
ठीक है।
all the three matters we had analogously.
है जी।
One matter is not in the list. Item number 696, 109, and another matter is
Not 109, 3109 of
ওই number
2025.
no ওনার নাম্বারটা এটা যেটা
In this matter, I am ready, my lord.
all the
If
three
you are
matters. This is
here,
related to Pashchim.
no. Uff.
ওই ফাইলটা
No,
আনিয়ে নি
all the
coming
three-
with
No, Usti matter is not of Paschim Medinipur. Usti matter is of South 24 Parganas.
joint prayer of the parties list this matter on 17th.
Along with item number 109.
Give that number, I'm not recording, give that number, you will get that.
Yes, 1009 আর একটা ফাইল আছে।
Mr. Banerjee,
Yes, my lord, item number 697, my lord.
97, there is a order passed in this writ petition that the issues are similar. This was submitted on behalf of the state. 697.
No,
who
my
is
lord,
that?
I say, my lord, it is not, sir.
We have given their report, we'll take it up on that day. Yes, who is appearing for this state in 697?
We have no idea.
697 এর স্টেট কে কে অ্যাপিয়ার করছে এখন?
এখন কি appear করছে?
697 এর
On earlier occasion, Mr. Somen they appeared, but that list is changed, my lord.
My lord, may I just
I don't
clarify,
know.
this is not a similar matter. They are claiming for A category scale. Here, my lord, we are claiming notional benefit as per ROPA 2009. On the notification dated 26 July 2019. Very short point. I mean, led by Mr. Shomo Mujumdar. This is absolutely a different matter, my lord.
In your matter, affidavits have been filed.
Yes. Affidavits have been filed, reports have been exchanged, everything.
State এর হয়ে কে আছে এটা? 696
The Anirbandha ছিল।
এই কি বলছেন?
If your lordship may direct that we will again serve the state.
Oh, 696, your lordship.
You are there.
If 696.
In 696, that is WPA 20328 of 2024, there is a report filed by the state.
My lord, that state,
That
my lord, I don't know, my lord, whether state is filed or not. But I filed, my lord, on behalf of the DPSC,
Secretary DPSC.
chairman of the DPSC. Yes, my lord, I have filed, my lord, on behalf of the DPSC.
Assistant Secretary Government has also filed a report.
Oh, then it's all right. ঠিক ঠিক ওটা একটা
So,
নিয়ম।
Banerjee, in 696, item number 696, there is a report from the DPSC as well as state. They have made a prayer that this should be tagged with your matters since the matters are analogous.
My lord, I have to take a
But
different stand.
also recorded in item number 696 that the submission was made on behalf of the
State respondents, yes.
My lord, I completely differ.
Well, that is not the correct. They are
Absolutely not correct. 696, my lord, relates to A category scale and
my lord,
697 relates to notional benefit. Both are completely different, my lord.
different.
Yes.
Completely different. My lord,
Analogous hearing will not be conducted in respect of your item. It will be segregated.
No, my lord, no, my
Not
lord.
required.
Yes.
তাহলে
The report is not correct.
নাম্বারটা দেবে ওটাকে 17 তারিখে লিস্ট করবেন। 696 will give that number.
Yes, 1009.
My lord, I shall pray before your lordship, my lord, all the matter, this matter and 3109 be heard, my lord, separately. That will be better.
Yes, that's why
My humble submission before your lordship, because in this matter, my lord, we have
Wait.
lordship.
696 and another number is
another number 1009.
1009.
And another not file is not here. The requisition has been sent.
Give those numbers. Give those numbers.
My lord, in
WP number 3109 of 2006.
Okay.
3106.
এটাকে on the joint prayer of the parties 696, the matter will appear on 17th.
Lordship.
Mr. Maiti, give the number
Yes.
which you intend to have heard along with this writ
That
petition.
is the WPA number 3109 of 2006.
Provide that number. ওটা আনিয়ে নিন। ডিটাকের কিছু নেই, উইথ নেই তো এটা না। Paper 697.
696.
Yes. 697. Who is appearing for
Good.
DPSC?
Well, there is no DPSC in the matter, only the state.
State.
Only state. Well, basically at page 28 of my writ petition, a new revised pay structure have been made for primary teachers in the year 2019.
Who is appearing for state in 697?
We have no instruction to cross.
No instruction.
No.
Team. এই এটা দেখো তো এটা স্টেটের কি আছে তাহলে ওকে বলবো এটা স্টেটকে নোটিশ দিতে অ্যাটলিস্ট
Our while impaneled advocate Mr. Anirban Roy was appearing.
Then you do one thing, you give a notice intimating the next date to the state. Find out who is appearing in this matter.
Well, may I kindly pass a direction that I'll serve upon the state again and fix a date, Milord. Upon
None appears on behalf
the
of
government
state.
leader.
Learned advocate for the petitioner is directed to serve notice upon the learned advocate for the state intimating the next date of hearing. Let him appear before this court. If he does not have the copy of the pleadings, then you can serve. You just intimate the next date of hearing. Let it come up.
Absolutely, man. I will definitely.
এটা একটা ডেট বলুন তো 2 সপ্তাহ পরে সার্ভিসের করে আসবে
Well, it is coming up on. Well, your lordship had fixed it on.
হিয়ারিং এ নিয়ে যান ওটা সব অ্যাফিডেভিট হয়ে গেছে 2 সপ্তাহ পরে এটা হিয়ারিং এ এদের আসবে Third September. 3rd September.
3rd September. Grateful, Bill. Grateful.
Under hearing listed রাখবে
398 are for the petitioner.
Yes.
The DPSC lordship.
The category scale of pay. At the same time, Miller, I am claiming Miller 18 years benefit also. And also prayer share, I also told Miller that was also taxed with Miller item 690 because I am also claiming Miller 18 years benefit also. I have completed 18 years benefit prior to Miller that notification of 26th of July 2019. That is why I am entitled to get that date which is accepted by the company.
This is not the case of overdrawl.
No, overall they have stated, but I am also entitled to get grade pay 3,900.
That would be decided later. First, first he regularize this whether he is entitled to get the A category or not,
Yes,
Milord.
category
Let it be decided. Thereafter, I mean, one petition, Milord, if he comes up with all these prayers, Milord.
Then first, that pair I can be challenged later on.
Yes.
Consider A category scale of pay. Yes. I am entitled to get
Which course?
Well, code was
2005 6
1719.
1719. Where is 1719 certificate?
Yes, kindly take up the supplementary certificate.
Page 9, I believe. Page 5, Milord.
Page 4.
Page starts with page 4.
All of them under Hooghly?
Yes, yes,
How many are there? 5.
yes, there are 5. Well, I've been granted a category scale of pay with effect from 18th of September.
I or we?
Well, they.
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 Kindly come to page 48.
They have been granted from which date?
18th of September 2019.
All.
All. I am entitled to get blood 22nd of May 2019.
Mr. Basumoli,
Lordship.
similar order
Yes.
can pass. You have checked this supplementary affidavit or
I have checked.
certificate?
My lord. Yes, certificate is there, my lord.
What is the name of petition number 1?
Honorable Sujit Kumar Khan.
Passed.
Yes.
Next.
Yes, my lord. Page 4.
Number
page
2.
Number 2,
Kamal Kumar Mondol.
yes.
Kamal
Kumar Mondal.
Yes.
That
Thereafter, my lord, Animesh Pramanik.
Yes.
Na, Oshimesh. Oshimesh Pramanik, my lord. Thereafter, my lord, Ramesh Biswas.
Yes.
And then, my lord, Bhupati Rai.
All.
This 5. This 5.
Affidavit of service. I file by the present writ petition, the petitioners seek direction upon the respondent authorities and taken even to a category. The factor near in. এটা ওখানে
মাফ করে নিস, তুমি দিয়ে দেবে
of DLED বলেছিল এখানে 25th May 2019.
যদি বড় হ্যাঁ সেই
Petition seeks direction upon the respondent authorities of grant of A category scale of pay on and from 22nd May 2019. That is from the date of publication of the results of Diploma in Elementary Education in short DLED course 2017-19. The petitioners contain that they joined as assistant teachers in different primary school under
Hooghly District
District Primary School Council in the year
Joint project.
prior of giving you.
two thousand.
And
In the year
1995.
2000 as untrained candidates. The petitioners have completed DLED course for the session 2017-2019, the results of which were declared on 22nd May 2019. The petitioners have been granted A category scale of pay on and from 18th September
2019, my lord.
2019. The petitioner claims that the A category scale of pay ought to be granted to the petitioner on and from the date of publication of the results of DLED, that is 22nd May 2019. The rest submission same by the end of September 2026, subject to verification of the other. Disposed of.
Get full.
By the end of September, the areas will be.
পরেরটাও তো আছে
সেকেন্ডটা তো হয়ে গেল তো।
হ্যাঁ 699 আছে 2234 এইটা
699
for the DPSC Hooghly lordship.
petition.
হ্যাঁ হ্যাঁ
This is from which course?
Well, same score. There is overdrawn is there.
First will be A category.
করিস না
All are A category.
Yes.
So A category.
আগে কি মামলা হয়েছে এটা
Again, in this there is no prayer for A category.
না না রেখে দাও এটা হয়ে গেছে
There is no prayer for grant of A category in this.
And below A category scale has been granted now subsequently below. Yes. Memo number P4 and except P4. Yes. They are saying that I am not entitled to academic. Kindly come to page 38. Because as I have enjoyed the 18 years benefit, therefore I am not entitled to get a category scale of pay. That is the challenge.
একটা কপি দাও তো, একটা জাস্ট কপি দেখি। এটা চ্যালেঞ্জ করেছে।
হ্যাঁ।
হিয়ারিং করেছিল নাকি?
তুমি রিপোর্ট দাও না একদম।
রিপোর্ট লিস্টটা হিয়ারিং এ পাঠিয়ে দাও না। ওভার এখন তো স্টেট আছে, ছাড়ো না। ওভারড্রান স্যালারি।
তুমি রিপোর্ট একটা।
What is your submission to this?
Now, my lord, page 40, my lord, kindly refund of overdrawal of salary of দাঁড়াও, 6 teachers. I find, my lord, in reference to the above, is hereby instructed to deduct the overdrawal. Overdrawal has been deducted, my lord, in this case, my lord. And my lord, thereafter, my lord, oh, the notification has been annexed. So, my lord, and the document at page 49, my lord.
Submit a report.
1, 2,
Otherwise,
3.
my lord, that will not be possible.
Report, my lord, then, my lord, the
Yes,
now.
yes.
Page 49 down a bit backward. Page 38, my lord. Their challenge is something else, my lord.
Same thing challenge.
Na, ekhane, but here, my lord, what has found from fallen from his lordship, my lord, aspirant number 5 to withdraw and rescind or cancel the memo dated 3/12/2019 annexure P4.
Annexure
That is page
P4,
38.
Annexure P4
Lordship.
is the document by which dint of which they have been refused a category.
My
If they get a category, then there is no overdrawal.
No overdrawal.
So what is your submission with regard to 38? Will you be filing any report?
Now, my lord, if that
Is
be
it
the
so that if a person is granted 18 years benefit, he is not entitled to that?
then, my lord, kindly come to page 41, page 40.
Yes.
Here, my lord, the chairperson has written a letter to the SI, refund of overdrawal of salary of 6 teachers.
That is in view of the annexure P4. If the annexure P4 goes, then this has no application at all.
But I don't find the dates, lordship.
Report
So far,
is
this annexure P4, my lord,
by the
that is of 2019. 12/9/2019 and this document আরে বাবা না এটা তোমার কবে কাজ 19 সালের কাগজ কোথায় এখানে এখানে কোনো কিছু নেই আরে কিন্তু এখানে কাগজ কোথায় এখানে ডেট নেই একটা আনডেটেড কাগজ
আনডেটেড কাগজ আমি
এটা তো এখানে কোনো ডেট
Basu Maulik, you take instruction, file a report regarding the observation made herein, whether a person who has been granted 18 years benefit is not entitled to a category scale of a fine.
এটা পাঠাবো আমার কাছে এক্ষুনি
By the present writ petition, the petitioner seeks for cancellation of the memo number 257717 within bracket 17/1/HDPSC dated 3rd December 2019 and fixation of grade pay of the petitioners on and from 1st April 2019 at the rate of rupees 2,900 and rupees 3,900 from 1st August 2019 and other consequential benefits, including arrears of salaries. Mr. Vishwabroto Basu Maulik, learned advocate for the DPSC Hubli, seeks to file a report. Let such report be filed within a period of 2 weeks. Exception, if any, be filed within a week thereafter. Please this matter after 3 weeks. The hearing a list of them.
Grateful.
After 3 weeks under the heading hearing. Advance copy of report, you file your exceptions, whatever.
Hearing will take some time. They are going.
I have fixed a date for hearing. On Thursday, this will appear. After 3 weeks.
আপাতত ডিপিএসসি উত্তর দিনাজপুর।
What is this? This is for
A category.
1719. How many petitioners are there? One.
I have already corrected.
না দরকার নেই।
Affidavit of service filed on behalf of the petition is taken on record by the present writ petition. The petitioner seeks direction upon the respondent authorities, particularly respondent number 4,
700.
District Inspector of Schools, Primary Education, Uttar Dinajpur, for grant of A category scale of pay, including area to the petitioner on and from the date following the last date of final examination of diploma in elementary education in short DLED training course 2017-2019, that is 17th March 2019. In terms of memorandum, you can take an evidence. The petitioner contains that she joined as an assistant teacher in which school? Assistant teacher in a primary school under DPSC HON'BLE. HON'BLE, this is?
না উত্তর দিনাজপুর।
Uttar Dinajpur in the year 2017 as an untrained candidate. The petitioner successfully completed DLED examination for the session 2017-2019, the results of which were declared on 22nd May 2019. Stop. The petitioner was granted, has been granted A category scale of pay from 1st July 2022.
Paragraph 11.
However, the petitioner is entitled to A category scale of pay from date following the last date of final examination of DLED training course. Stop. Hence, this writ petition rest same. End of September 2026. Arrears. Anyway.
I am for the DPSC election.
One petitioner.
Uttar Dinajpur.
উত্তর দিনাজপুর।
Similar order. Affidavits you have given?
But I have already given.
What is date of year of joining?
Well, 17.
17.
But para 4 I have indicated.
Okay. Same order.
দিচ্ছে সব দিয়ে দিচ্ছে পরপরই তো আছে।
702.
মানে আপনাদের ডিপিএসসি election.
The only difference is that here the category has not been matched.
Certificate?
Well, at page 13 and 14.
Same order করবেন. The petitioner has not been granted A category scale of pay till date. The petitioner claims A category scale of pay on and from the date following the last date of final examination of DLED training course, hence this writ petition. The rest same.
Grateful. হ্যাঁ তিনটেই আছে।
703. May please Lordship, I am for the petition. This is also my category. My and there is order. In spite of that, my lord, so we have annexed a order. That is annexure 1 year category, and that order also passed in the instant case, my lord. I am taking same order.
13408.
This order was, my lord, only to consider their representation.
No, earlier we have considered,
We have considered the representation, we have rejected it, my lord.
That is
May I
clear.
please that?
That will be a annex. But here, more than 1% has been appointed as per order of this court. My lord has inquired into the matter. There in fact, why this person will not take. That was the last.
This is 99, 2000.
Same pair and
15. He has completed DLED on which date?
my lord, last order. As per your lordship, Raja Shikhar Mantra.
Tonima.
This order considered and rejected, and also there is order because this is page 22, annexure P6. Page 22, annexure P6. Well, can you see page 22, annexure P6? 1 year has been considered and given direction to pay a scale to the petitioner. They have done this similar pair in this case and same order.
What is your claim? From which date?
That is the order. I am entitled to take age category. I have been appointed as per order of this Honorable High Court. 37/2015, 7 years, 9 years already passed.
31st July 2015 you joined.
30th July 2015 is my appointment date.
Filing service.
Nine years already passed.
Where is that geo dated?
But only one,
March.
but only one thing, my lord. May I just hand over this instruction? Now, my lord, they have the petitioner. Lordship, can you take page 2, my lord? As per, my lord, paragraph C. As per para 2 of notification number such and such dated such and such of school education department, A category scale of pay may be allowed to the teachers who completed 1-year diploma in primary teacher training course and appointed after 31/12/2005. This is not the case with this present petitioner, my lord.
Category pay may be allowed to teacher who completed 1-year diploma course appointed after 31st. This will not apply in his case.
This is not applying, my lord. They have not done it.
How he is distinguishing? What is the distinction between the notification which provides that after 31st December
Yes.
2005 and how this is not applicable?
My lord,
is
because they have not done the diploma course. This particular petitioner, they have not completed this course.
No,
We are not
prior
on to
to-
bridge, my lord, bridge course.
Prior to joining, she has completed training course.
My lord, but that is not this course, my lord.
Where is that notification?
So Malakali order, it is clear 1 year's course she is entitled to get a grade category. I have annexed all.
Where is that notification? 4th March.
My lord, I'll look at that immediately.
Lordship, kindly see our reply, Lordship, on behalf of the state's Lordship.
State?
Yes, Lordship.
The notification is
Previously, notification is there, Lordship. Previously filed by the state Lordship.
Report date bolo.
Report dated
1770.
You have been granted A category.
My-
A category has been granted to you.
No, Lordship.
I am entitled, and as per this order, there is a order for 1 year. They got the age category. There are many
23rd
persons
March.
employed as per order dated, and it's a P6. Page 22, 1 year has been allowed, and I'm 1 year also, 1999 to 2000. I passed primary teacher training final examination 1999 to 2000 in the first division. That is the paragraph 6 annex
যেখানে
P3.
রয়েছে সেখানে করেছে।
Your report.
No, I'm entitled as for that. They have given all the candidates a grade category.
No, where is that notification you just indicated?
Earlier, there is a report filed by the
States,
earlier-
Lordship,
by the
earlier.
state. That has
On 23rd March, Lordship.
report in the
Report
form
that
of that.
particular.
Lordship, before that, kindly see the page number 3, Lordship. In our
See that notification.
notification is page number. Page number 6, 7, 8.
8.
8.
My lord, if your lordship, can you take
11,
page 8?
Page
4th
11.
March 2000.
4th March.
Yes, my lord.
Page 11 of the writ petition.
Yes, my lord. There's some mistake in the pagination here, my lord. If your lordship kindly sees, my lord, 1, paragraph 1.
Roman 1. Yes, 50%, at least 50% marks. In petition number 32.5.
The bridge course you have completed.
Huh?
You have completed the bridge course. Bridge course you have completed.
I have completed.
Bridge course you have completed.
This only 1 year that I have annexed. This code you have not, and my lord will find the order. It's a clear case where 1 year is allowed. My lord, kindly see page 22 annex P6. Now they are drawing attention of 2013, and the order passed in 2024.
She has not disclosed anything what she has done, my lord.
2024.
You go through the judgment.
And they have
You go through the judgment in paragraph number 5 of the division bench's order,
My lord,
which has been noted in that particular paragraph,
my lord.
and find out what was the findings therein. If suppose this particular notification says that a person who joins after 31st December 2005. He has joined on 31st July 2015.
My
That
lord.
means after that period,
Yes.
if he has 1 year PTT course and subsequently completes a bridge course, if the division bench says that if completing 1 year will entitle him to a category scale of pay, then we cannot.
I will
work
find
that.
it.
Huh? You just go
I
through
will
that. Mr. Haldar, you also go through that. 7/14 of 2020. Okay. Next day we'll take it up. Ajke just not today karo. Next day we'll take it up.
Next Monday.
Next Monday.
My lord, this year.
That paragraph, Mr. Kankani,
My lord.
paragraph number 5.
Yes, my lord.
জানি না এদিকে বলছি নেবে বলছি
তুমি পাঠিয়ে দাও।